long as they need to deliberate. So that's our schedule, our time schedule. It is a good faith estimate. Sometimes cases go longer, sometimes they're shorter. What I can tell you is at every jury trial, at the end of the day, I tell the jurors whether we are on track, whether we are ahead of schedule, or whether we're behind schedule. And I have not had to say that we are behind schedule, I think, ever. So we make every effort to make the best use of your time because we know how important your time is to you. The daily schedule will be that we'll start at 9 o'clock in the morning. We'll take a break for about 15 or 20 minutes, sometime around 11 o'clock. Then we'll break for lunch sometime around 1 o'clock. Lunch will be brought in for you folks every day. Again, it's an effort to make efficient use of your time so you don't have to walk down to the center and come back. The luncheon break will be about 30, 40 minutes each day, and then we'll go until about 4 o'clock in the afternoon. If we go any later, I always ask the jury if it's okay with them if we go later. So the latest we would go would be 4:30 if we wanted to finish up a witness. So that's our schedule. There will be a few days and few half days in there sprinkled throughout, and I'll give those dates to the seated jurors at the time. So that's the schedule we'll be working from. Now, it might help if I give you a preview now about some basic law that applies to criminal cases like this. It's my job to teach the jury the law at the end of the case, but for now, I'll give you a very brief summary of some very important constitutional principles that will govern this trial. First, and most basically, Ms. Reed starts this trial presumed to be innocent. The fact that she was arrested or that she was indicted is not proof of anything. An indictment is simply a piece of paper. It just makes an accusation. An indictment is a formal manner of bringing a case of a person accused of a crime before the Superior Court in this case. But it is only the jury, in other words, you folks, who can decide whether the prosecution has proved its case beyond a reasonable doubt. If the Commonwealth does not do that, then the presumption of innocence requires you to find the defendant not guilty. The law does not require a defendant to prove her innocence, to produce any evidence whatsoever, or to do anything other than attend the trial. This presumption of innocence remains with the defendant until you, the jury, make your determination after listening and considering all the evidence. Another important principle of law is that the defendant has an absolute right not to testify, since the entire burden of proof in this case is on the Commonwealth to prove that she is guilty. Under our system of law, a defendant has a perfect right to say to the jury, "You accuse me, now you prove it, and prove it beyond a reasonable doubt and to a moral certainty. I do not have to say a word." A defendant's decision whether or not to testify has nothing to do with the question of whether she is guilty or not guilty. The jury must not consider it in any way or even discuss it at all in their deliberations. Jurors in a criminal case must determine whether the Commonwealth has proved its case against the defendant beyond a reasonable doubt based solely on the testimony of the witnesses and the exhibits. That brings me to the requirement of proof beyond a reasonable doubt. What is proof beyond a reasonable doubt? The term is often used and probably pretty well understood, though it is not easily defined. Proof beyond a reasonable doubt does not mean proof beyond all possible doubt, for everything in the lives of human beings is open to some possible or imaginary doubt. A charge is proved beyond a reasonable doubt if, after you have compared and considered all of the evidence, you have in your minds an abiding conviction to a moral certainty that the charge is true. When we refer to moral certainty, we mean the highest degree of certainty possible in matters relating to human affairs based solely on the evidence that has been put before you in a case. I have told you that every person is presumed to be innocent unless and until he or she is proved guilty, and that the burden of proof is on the Commonwealth. If you evaluate all the evidence and you still have a reasonable doubt remaining, the defendant is entitled to the benefit of that doubt and must be acquitted. It is not enough for the Commonwealth to establish a probability, even a strong probability, that the defendant is more likely to be guilty than not guilty. That is not enough. Instead, The evidence must convince you of the defendant's guilt to a reasonable and moral certainty, a certainty that convinces your understanding and satisfies your reason and judgment as jurors who are sworn to act conscientiously on the evidence. This is what we mean by proof beyond a reasonable doubt. Our system of justice depends on judges like me and jurors like you being able and willing to make careful and fair decisions. All people deserve fair and equal treatment in our system of justice, regardless of their race, national origin, religion, age, ability, gender, sexual orientation, education, income level, or any other personal characteristic. You have agreed to be fair, and I am sure you want to be fair, but that is not always easy. One difficulty comes from our own built-in expectations and assumptions. They exist even if we're not aware of them and even if we believe we do not have them. Some of you may have heard this called implicit bias, and that's what I'm talking about. Of course, we judges have the same problem as everyone else, so let me share a few strategies that we have found useful. First, slow down. Do not rush to a decision. Hasty decisions are more likely to reflect stereotypes or hidden biases. Second, keep an open mind. Avoid drawing conclusions until the end of the case when you and your fellow jurors deliberate. Remember that when you deliberate, you will have all the evidence and all the time you need to make a careful decision. So there truly is no need to start making up your mind before then. Third, you should listen closely to all the witnesses. That is the best way to ensure that you decide this case based on the evidence and the law instead of upon unsupported assumptions. Fourth, as you listen to the testimony about the people involved in this case, consider them as individuals rather than as members of a particular group. And finally, I might ask myself, would I view the evidence differently if the people were from different groups, such as different racial, ethnic, or gender identity groups? At the end of the case, I will remind you of these strategies and ask you to focus on the evidence instead of any unsupported assumptions you may have. All we ask is that you, individually and as a group, do your best to resolve this case based upon the evidence and the law without sympathy, bias, or prejudice, to the best of your ability as human beings. Now, I know that some of this may be confusing, and perhaps all of it's confusing at this early stage. Please don't worry about it, because you'll be in a better position to understand this at the end of the case when you've heard the evidence and when I can explain the law in detail. So don't be worried if you didn't catch everything I've said. Why am I telling you these things now? Because we need to know if you are able to follow the law in this case. You don't necessarily have to agree with the law, but all jurors will have to apply the law as I describe it to you. So for jury selection, it's important to know if any of you might have some doubts whether you can accept and follow these legal principles. So now's a good time to take out your card, because I'm going to start asking you questions in a minute. So if your answer is yes to any question, I'd ask that you raise your hand. But before we begin, I understand that sometimes jurors do not fill out the questionnaires completely. Sometimes we're just in a hurry to get those forms back in, or we think that our situation doesn't apply to the question being asked, or sometimes we simply forget to put something on there. If the lawyers or I see that there's something that's missing, we will ask you. But if you're sitting here now and you realize that you maybe didn't include prior work history or prior involvement with the courts as a defendant in a criminal case, as a witness to a case, as a juror, anything that you know that you didn't include, I would ask that you tell us at sidebar. And if we see something, what happens with some frequency is people forget to put their age on there. We have to ask you because we have to keep a record. All right, so my first question. Do any of you folks or a close personal friend or family member know, or have you had any prior dealings with any of the witnesses? If so, please raise your hand.
1083 1108 1093 1100.
Thank you. Do any of you folks or a close personal friend or family member know, or have you had any prior dealings with any of the lawyers or the Norfolk County District Attorney's Office? If so, please raise your hand.
1100 1114 1086 1108.
Thank you. Do any of you folks or a close personal friend or family member have any financial or other personal interest whatsoever in this case or its outcome? I see no affirmative responses. I'm going to ask you to raise your hand if you have seen, heard, or read, or talked about this case.
One 1136 1198 1098. My apologies. 1068 1090 1120 1082 1109 1138 1075 1108 1125 1063 1091 1134 1087 1131 1102 1106 1137 1083 1088 1079 1097 1123 1122 1080 1086 1114 1092 1072 1141 1139 1093 1140 1066
1107 1085 1127 1119 1115 1112 1121 1096.
Thank you. Please raise your hand if you have formed or expressed an opinion in this case.
1136 1098 1068 1090 1120 1082 1109 1138 1075 1108 1063 1131 and 1083 1097 1122 1086 1072 1093 1140 1066
1107 1085 1115 1112 1121 1096.
Thank you. Are any of you folks aware of any bias or prejudice that you may have in regard to this case or in favor of or against either of the parties? If so, please raise your hand now.
1131 1120 1068. 1108. 1097. 1093. 1140.
1085.
Thank you. Do any of you folks have any difficulty hearing or any problem with understanding the English language, any physical or mental condition, or any religious or philosophical beliefs that would interfere with your ability to hear the evidence in this case, to understand the evidence, to concentrate during the trial, or to deliberate for the purpose of reaching a verdict? If so, please raise your hand.
1068, 1073, 1142, 1078.
Could you say that one again?
The last one?
Yes.
1078,
Thank you.
1103, 1129.
Thank you. Do any of you folks have any difficulty understanding or following those very important constitutional rights that I told you about? First, that the burden of proof rests entirely with the Commonwealth. Second, that that burden of proof is proof beyond a reasonable doubt and to a moral certainty. And third, that the defendant has absolutely no burden. She doesn't have to testify. She doesn't have to put on any evidence. All she needs to do is show up for the trial. Is there anyone that would have any difficulty applying those very important constitutional principles? I see no affirmative responses. I can tell you folks that after every jury trial, I go in and I talk to the jurors, and though they may not have been thrilled about having jury duty when they walked in for the first time, by the end of the trial, there have been people on every single jury that have told me that they found their experience to be an interesting one, and many people have told me that they've also found it to be a rewarding one. But I do understand that for some of you, sitting on this jury could be a substantial hardship, and let me tell you what I mean by that. Every civic duty we have causes us to be inconvenienced. What we're talking about here is something much greater. It means that it's something personal to you. That means that I excuse you, and the person next to you has to take your spot. I generally think of it in terms of you have airline tickets or surgery scheduled for the time that we will be on trial. But I will hear from anyone who thinks they have a substantial hardship. If that's you, please raise your hand.
1136, 1098, 1131, 1073, 1134, 1090, 1091, 1109, 1063, 1070, 1075, 1108, 1083, 1092, 1080, 1072, 1141, 1139, 1093, 1111, 1066, 1140.
1115, 1121, 1096.
Great, thank you very much. I am going to leave the bench in a minute to give you a chance to fill out those supplemental questionnaires that will be provided. I'd ask that you not talk to anybody about those questionnaires, that you don't talk about your answers, you don't talk about any questions or concerns that you might have about jury duty, either in general or in particular to this case. If you have any questions or concerns, please bring them up when you come to see me. Again, I thank you for your patience, and we'll see you in a while.
All rise for the court, please.